and then I went up to York for the next 17 years. I came from York. I went up to Hull for the next 17 years. I was asked...
How did the Bentham project have such an effect on you that
exactly.
you're not sure exactly where you were?
Yes, that's right. I have to return to Yorkshire and hide. No, so thank you very much, Philip, for inviting me back. I'm honoured to be here. The paper grows out of something I was invited to do, which is somebody got an AHRC grant and they were doing something on privacy, and a lot of it was contemporary stuff and surveillance society and that sort of thing. So they asked me to write a paper about Bentham in that context, and they expected me to give a paper in which I basically followed the Foucauldian line, which I didn't do. And this is the paper that I wrote. The conference organizer for that is now written his own attack on this sort of panopticon approach from the Foucauldian perspective, broadly speaking. But this is an attempt to try and set some of the records straight. So in that context, given that many of you will have been studying Bentham far more intensely recently than I have, you will know this already. But so I apologise for that. The last part, though, does deal with privacy, which very few people seem to have covered. And it's tucked away in bits of Bentham that people rarely turn to, particularly the darker parts of the rationale of judicial evidence. But anyway, so this paper is called Jeremy Bentham on Open Government and Privacy. So the auto-icon then isn't just a strange joke by a strange man, although it's that too. Rather, the auto-icon is Bentham's attempt to try and debunk the socially harmful prejudices that surrounded corpses in the early 19th century, and particularly to debunk the then Christian notion of the literal resurrection of the body on the Day of Judgment. The attempt was characteristic of the man because Bentham was an Enlightenment figure. That is, he strove to replace obscurity, prejudice and myth with reason and evidence-based knowledge. Bentham argued throughout his literary career that only by doing so could one begin to counter the vested interests which the rich sought to promote through their exercise of their inordinate power. Even his infamous panopticon was part of this project. It was a prison at whose heart stood a central observation tower encircled by layers of cells, which enabled the guards to see every corner of the prison's accommodation without themselves being observed. As Bhikkhu Parekh has noted, quote, it was not a metaphor for Bentham's society, which was really quite liberal in several respects, and it was a cheap and centralised way of constructing large prisons whose internal regime was not particularly harsh, end quote. In Bentham's terms, it was part of his grand attempt to achieve the two key aims of a good state: official attitude maximised, expense minimised. This article sketches the key political dimensions of Bentham's utilitarianism, focusing particularly on the central importance he placed on freedom of information as a necessary condition of the effective monitoring of public officials by civil society groups and individual citizens. Section 2, which I'll move on to shortly, outlines the critical dimensions of Bentham's political theory, particularly the need to debunk metaphorical and obscure language, so as to enable citizens to understand the real forces and interests at work in the world. Section 3 turns to his later constitutional theory, emphasising its radically democratic elements. Section 4 focuses on Bentham's theory of open government, emphasising its reliance on public scrutiny of the actions of office holders, a function that he assigned to what he called the Public Opinion Tribunal. Section 5 analyses the place that he ascribed to personal privacy through a discussion of his liberal attitude towards sexual practices. And Section 3 reflects on the cogency and contemporary relevance of Bentham's theory. So the next section is fallacies, utilitarianism and government. Bentham lived from 1748 to 1832. Domestically, Britain saw rapid urbanisation and industrialisation, as well as associated declining aristocracy. Despite these profound changes, the country remained custom-bound and profoundly hierarchical. Poverty, illiteracy, crime and disease were rife amongst the poor, while corruption and competing vested interests were rife among the rich, something that was reflected in regional and national government as well as in the professions, especially law, the church and medicine. To Bentham's eyes, these sinister interests used complex, slow, expensive, specialist languages and procedures to exclude outsiders and to justify their privileged position. The use of nonsensical concepts was not restricted to the legal, ecclesiastical or medical professions, however. They were central to all areas of social and political life, being embodied within the very language that provided the substance of those fields. Bentham dismissed such powerful concepts as were found in the French Declaration of Rights of Man and Citizen of 1791 and elsewhere, including the social contract and natural rights. Indeed, famously, he dismissed natural and imprescriptible rights as liberty, prosperity, security, and resistance to oppression as nonsense upon stilts. These were famously anarchical fallacies, in that they were fictions which, if applied literally, made government impossible. Each natural right was said to possess an absolute authority, meaning that when they clashed with each other, neither had priority over the other. Moreover, their absolute authority placed unassailable limits on the legitimate actions of the state, irrespective of the current needs of society as a whole. In this way, such terrorist language, that's a quote from Bentham as he called it, was profoundly dangerous. Bentham argued that rather than appealing to what were at best rhetorical flourishes, society and government should be founded on clear and specific concepts, which, when organised and employed in a rational manner, tended to serve the real interests of the whole community. Bentham developed a theory of government that would operate on the correct normative principles, he believed. He began from the axiom that although different people value different things, at root every individual was motivated to seek their own pleasure and to avoid their own pain. He saw this fact as being profoundly important in politics, as it ensured that the society which the government ruled was nothing more than a mere collection of self-interested individuals. I then quote the famous passage from IPML in which he sets that out. On the basis of this hedonistic psychology, and not without making some rather obvious logical jumps, Bentham concluded that the highest value which the government should pursue was the maximisation of net pleasure among society's members viewed as an aggregate, or as he famously put it, the greatest happiness of the greatest number is the measure of right and wrong. Although Bentham insisted on this principle for the whole of his adult life, it contains crucial ambiguities. For example, while he gave many examples of types of pleasure and pain, he never published a clear explanation of what he meant by these terms at the generic level. The closest he came to doing so seems to have been when he wrote in his still unpublished manuscripts that, quote, "I call pleasure every sensation that a man would rather feel at that instant than feel none. I feel pain every sensation that a man had rather feel none than feel." There were even more fundamental problems for Bentham's greatest happiness principle, not least the fact that it is incapable of producing determinate authoritative policy judgments or prescriptions, because it established no priority between its two key variables, the greatest happiness and the greatest number. Should a government seek to secure the greatest happiness, say, of 51% of the population, even at the expense of the remaining 49%, or should it seek to maximise the greatest possible aggregate pleasure of the whole population? They're familiar objections. Bentham himself was unable to overcome these difficulties. Nevertheless, he applied the greatest happiness principle to justify a great many very specific policies. In international affairs, he sought to end slavery and colonialism, and argued that war should be waged only in national self-defence and as a last resort. He argued for the recognition of the equality of all states and called for asylum to be granted to all oppressed foreigners. Moreover, he used the principle of the basis of his defence of open government, as will become clear shortly. So far, this section then has set the scene for an analysis of Bentham's political thought. It began by outlining the social and political context in reaction to which Bentham developed his utilitarianism, especially the prevalence in society of sinister interests, and the links he saw between the power of the wealthy and the use of obscure and misleading modes of discourse. Finally, it highlighted some serious problems with his greatest happiness principle. Against this background, I'm going to sketch Bentham's favourite constitutional arrangements before analysing the importance he attached to open government and publicity. So Bentham's constitutional theory. The shortcomings of late Georgian politics are so well known that they almost do not need repeating. Only a tiny minority of the population could vote, and almost all of that group were wealthy men, with many constituencies being rotten boroughs. Deep corruption was widespread throughout British society and in its imperial territories. Bentham spent much of his life condemning both British imperialism and British society more generally. As the thousands of pages of published and unpublished writings attest, his attacks were not merely occasional or abstract rants. Rather, they were unrelenting attacks on both individual politicians, peers, and many other members of the gentry and business classes, but also detailed critiques of the practice of government and its civil servants, of lawyers, doctors, and churchmen. His particular bête noire was not merely the wastefulness of the networks of sinister interests, but the secrecy and unaccountability of the labyrinthine establishment. I should say, although I say some quite critical things of Bentham, as with many people, the more you read him, the more you like him, the more you think there is something there. So I'll enter that caveat. For many years, Bentham hoped that the government could be persuaded to reform itself from within, primarily through its use of reason and good sense. However, the continuing failure of the government to adopt his plans for the panopticon in a thorough reform of the penal system led him to see the British government as an irredeemably corrupt institution, which existed solely to serve the sinister interest of its members against the good of society. Even after his loss of faith in the possibility of benevolent despotism, which occurred in the early years of the 19th century, Bentham did not restrict his contempt to the wealthy and well-placed. The oppressed and exploited were complicit in the system's survival. He was emphatic, as he wrote in the 1816 advertisement for his paper Defence of Economy against the Right Honourable Edmund Burke, quote, "Submission and obedience on the one part are the materials of which power on the other part is composed." End quote. It was only by the use of force, if by anything, Bentham wrote, quote, that such of them whose teeth are in our bowels will be prevailed upon to quit their hold. The more you think about that metaphor, the worse it gets. The type of force which Bentham favoured most fully was generated by the interaction of his hedonistic utilitarian constitutional principles, rational democratic structures, and open government. Hence, he was very happy to work with liberal governments that came to power across the world through the violent overthrow of preceding oppressive governments, such as happened in Greece, Tripoli, and various Latin American revolutions of the 1810s and 1820s. Bentham expounded his constitutional principles most clearly in his unfinished and posthumously published book, Constitutional Code, Volume 1, Hereafter Code, a work which he intended, quote, for the use of all nations and all governments professing liberal opinions. He argued that, quote, the all-comprehensive and only right and proper end of government was the greatest happiness principle, end quote. In other words, the ultimate aim of the government, which the government should seek, was the greatest happiness of the greatest number of members of the community. The myth has grown up that Bentham believed it was possible to measure utility precisely and to calculate which of the available options would lead to the best outcome. In fact, he didn't make this highly implausible claim. He did dedicate the fourth chapter of IPML to, quote, considering the value of a lot of pleasure and pain, how to be measured. In that, he considered the factors affecting value of a particular feeling of pleasure and pain, its intensity, duration, certainty, propinquity, fecundity, purity, and extent. Yet, he did not argue that this calculus relied on precise numerical measures of pleasure and pain. He was sceptical regarding the possibility of quantification, invoking ordinal measures instead. In fact, Bentham was an indirect or rule utilitarian. He believed that the greatest happiness principle was too vague to serve as a precise guide to political action. For this reason, he argued that government should aim to serve a number of more concrete aims, which he called the specific and direct sub-ends of government. He organised these into positive and negative goals. By positive goals, he meant the quote, maximisation of subsistence and abundance, as well as security against evil in every shape, end quote, as well as the maximisation of equality. In other words, the government should aim to create and sustain conditions under which its citizens can both meet their needs for physical survival and prosper. By the all-comprehensive negative and collateral sub-ends of government, Bentham meant, quote, the avoidance or minimisation of expense in every shape. Obviously, this negative end was particularly significant, given Bentham's hatred of the abuse of government posts to feed the sinister interests of office holders, such as politicians, civil servants, and indeed anyone whose private finances and reputation benefited directly from the state. The other key elements of Bentham's constitutional structure concerned the structure of the democratic system. Specifically, he argued for the introduction of a codified constitution, the holding of annual elections for all members of Parliament, the replacement of multi-member constituencies with single-member constituencies, the granting to constituents of the power to dismiss their representatives at any time, and the introduction of a robust separation of powers within the highest parliamentary authority residing in the legislature. He argued for both the abolition of tests of religious and other beliefs for the franchise and university degree courses, and the abolition of the House of Lords so as to create a unicameral legislature. At his most radical, he even argued, shock horror, for the enfranchisement of women, although he didn't support the female franchise in the code. Moreover, he wished to see the legal and penal systems transformed. In opposition to the distorted laws of his own day, he insisted on the need for a single, simply stated system of known laws for everyone, and for the universal application of trial by jury. He insisted on the importance of clear, simple, cheap and impartially applied legal procedures for legal cases not to be protracted needlessly and for convictions to be based on solid evidence. Finally, where guilt was established, he insisted on the application of punishments that were both proportionate and humane. Through these measures, Bentham hoped that the corruption-sodden politics of the early 19th century could be replaced by a democratic politics in which reason and humanity would emerge from the wills of society's self-interested citizens. We're going to move on now to open government. It should be no surprise that Bentham was a staunch advocate of open government, given his hatred of vested interests and the mists of secrecy and obscurity with which they surrounded themselves. Within the first 30 pages of his massive code, Bentham had turned to the vital importance of public opinion as a check on politicians and all other public functionaries. Hence he placed what he called the Public Opinion Tribunal at the heart of the constitutive authority of the state. Quote, the sovereignty is in the people. It is reserved by and to them. It is exercised by the exercise of the constitutive authority. End quote. It was the constitutive authority which grounded the authority of the remainder of the state, that is, the legislature, executive, civil service, and judiciary. The constitutive authority was to be made up of a whole body of electors belonging to this state, he wrote. A group which, in the code, included all men over the age of 21 who were able to read and who were not what he called passengers, by which he appears to have meant those who were not merely visiting the country. The constitutive authority, and only it, had the ultimate authority to appoint and remove politicians and other public functionaries, including but not restricted to the Prime Minister, ministers and judges, and to order the trial of any public functionary whom it removed from office for misconduct. As Bentham had already noted in an unfinished essay of 1822 entitled Security Against Misrule, the Public Opinion Tribunal was a fiction, but a useful one. Probably Bentham had in mind that it was not a real tribunal. Indeed, it did not refer to an organised body of persons at all. It had no stable membership, no internal structure, no constitutive or substantive rules. In fact, as Bentham observed in the Code, the Public Opinion Tribunal was made up of anybody in the world, whether male or female, citizen or not, who took an interest in the actions of the various public functionaries who made up the formal branches of the state. Members of the Public Opinion Tribunal exercised their various powers when they monitored, assessed, and when necessary protested against these actions. Some of its members would listen to debates in the various national and lower legislatures, courts, and administrative forums. They or others of its members could organise and participate in public political meetings or plays with a political subject, as well as speaking or writing on political subjects. Bentham argued that in this sense this amorphous group could be considered as being made up of, quote, so many committees or subcommittees. Moreover, its multifaceted deliberations had its quasi-legal function along the lines of the common law, in that although its deliberations were not organised centrally, still it applied something very like laws to the actions of public functionaries. Moreover, it gathered and assessed information that was relevant to this task, as well as censoring recalcitrant functionaries. In that it expressed itself through the individual votes of its electors, it determined who would hold public office. Ultimately, the immediate weapon at the command of the Public Opinion Tribunal was publicity. As Bentham wrote in Securities Against Misrule, wrote, "It is by publicity that the Public Opinion Tribunal does whatever it does. Any further than employment is given to his weapon, the workman cannot do anything." With this in mind, Bentham argued in Code that the Constitution should both protect the negative conditions of public scrutiny and actively generate the positive conditions. Negatively, the government should neither ban nor tax public discussion of political matters, broadly conceived, for example, as that occurred in newspapers and the like. It did wish to retain the law of defamation, quote, if the remarks were mendacious or temeric. I can't say the next word.
Temerarious.
Thank you. But otherwise, he argued that the state should allow complete freedom of expression, except where issues of national security were at stake. Even when they were at stake, he insisted on the need for careful and independent scrutiny to ensure that security laws were not being used as masks for oppressing the Public Opinion Tribunal. It's all very relevant, isn't it? It's all very relevant. Snooper's Charter, Donald Trump. Anyway, positively, Bentham's liberal constitution created a legal obligation on all functionaries to generate relevant information needed to facilitate the work of the Public Opinion Tribunal. This extended to the question of criminal prosecutions, which were to be held in public with full disclosure of evidence, except where matters of the most sensitive nature would be compromised by such disclosure. The judge was to decide which evidence was of this type, although the strong presumption should be that it was not, particularly given the frequent closeness of judges and the administration and the potential corruption to which the closeness might lead. Explicitly, Bentham rejected the granting of privacy to cases involving popular sedition, civil disobedience, and the defamation of politicians. The Constitution required these functionaries to carry out these tasks initially through inspection and investigation. Moreover, Bentham was explicit that such investigations should not be restricted to public or quasi-public institutions, such as state-run schools and workhouses. Quote, whatever the establishment, institution or foundation, and however private, in no way can any interest which is not sinister be served by screening it from public inspection, performed through the medium of the authorities hereby for that purpose constituted. End quote. The powerful were not restricted to the government. They included entrepreneurs, lawyers, church officials and medical professionals. Now one might add media moguls, successful musicians and a great many other professions. Immediately this raises questions regarding Bentham's attitude towards the proper limits of investigations into individual affairs, and particularly regarding his attitude to the legitimate demands for personal privacy. And that's what the next section is going to look at. Bentham was conscious of the fact that insisting on complete publicity ran the risk of exposing what Mill, following Tocqueville, would later call the tyranny of the majority, increasing the vulnerability of the powerless. In the contemporary context of cybercrime and expansive systems of social media, complete publicity increases the likelihood of identity theft, trolling and the like. Bentham wrote surprisingly little about the importance of personal privacy, and what he did write divides scholars. Some scholars effectively ignore the question, turning instead to Bentham's defence of constitutional liberties, and particularly the fact that he justifies liberties of thought and expression as checks on public institutions, as just noticed. For scholars such as Douglas Long, this justification gave a very worrying slant to Bentham's beliefs, not merely regarding the proper limits of freedom of expression by individuals and groups, but regarding the types of ideas that could be expressed. As we saw earlier, Bentham required that public deliberations be conducted using language that referred only to real entities and to clearly understood necessary fictions. But Long concludes, quote, Bentham's purposes remained manipulative in spite of his endorsement of specific sorts of liberty. If he did not see himself as aiming to restrict conscious deliberation, that was because his real purpose was to redefine both consciousness and deliberation, and in so doing, to define the person in largely reactive terms. Only within the boundaries established by the sciences of human nature would it be considered expedient to stimulate public discussion and debate, Long concludes. The Public Opinion Tribunal was to carry out its work using what Bentham saw as appropriate non-fictitious terminology and utilitarian values. He held that to the extent that it didn't do this, criticism would allow irrationality to creep back into their deliberation. Critics, would allow irrationality to creep back into their deliberations. To the extent that harmful deliberations influence the public realm, legislation, government and practice, and ultimately the lives of individuals will be corrupted. Many difficulties arise from Bentham's requirement that public discussions and investigations be conducted making reference solely to real entities and necessary but clearly understood fictions. Firstly, even his most concerted attempts to design deconstructive techniques whereby social critics could both, firstly, identify the sets of real entities and useful fictions, and two, distinguish members of this set from fictitious entities and harmful fictions, suffered from logical flaws. His failure to establish criteria by which to justify his choice of real entities meant that ultimately his deconstructive techniques relied upon his largely personal beliefs about the nature of reality. Secondly, Bentham held that only specialist censors would have the expertise and time to apply his deconstructive techniques. In the second case, he argued that other censors could use the set without having been involved in designing and justifying them. Yet he recognised also that these practical censors were in constant danger of falling into error because of their relative distance from the work of the more philosophical censors. The terms practical censors and more philosophical censors are required, I think, to capture Bentham's meaning, even though he didn't use the terms himself. The implication was that the practical censors would be required to consult the more philosophical censors regarding the criteria to be used, a requirement that would give great practical power and responsibility to the more philosophical censors. This division of tasks might be ameliorated to some degree by Bentham's aspiration to teach the principles of sensorial utilitarianism to the general population, in that some citizens might show some philosophical talent. Yet he seems to have thought that generally competent philosophical censors would be in agreement regarding the sets of real entities and useful fictions, and would agree on the reforms required by changing circumstances. In other words, Bentham had a great faith in the unity of conclusions that accompanied the exercise of enlightened judgment. It was partly because of this naive faith that D.J. Manning, in D.J. Manning's words, Bentham did, quote, not seem to have considered it necessary to prepare a defence of individualism or privacy. Yet it's important to be careful here, because this does not mean that Bentham thought privacy to be unimportant. That's certainly the implication you get from Manning and others. Firstly, as Fred Rosen has noted, even though Bentham used the word privacy rarely, that was largely because he conceived of the fundamental issue as being how the law best maintains security. By security, Bentham seems to have meant, as Rosen put it, quote, the imposition on some not to interfere in the lives of others, end quote. Such imperatives applied to laws as much as to private actions. Rosen places great emphasis on the fact that Bentham saw law as the opposite to liberty, even if in practice one needs some laws to maximise liberty overall. Rosen concludes that the legitimate, quote, legitimate obligations to maintain security can be quite considerable, as the government acts, for example, to prevent invasion, crime, disease, and calamity, end quote. Hence, these actions might have required the individual to accept extensive state investigation, which would have been, quote, and these are quoting Fred Rosen again, which would have been destructive of the individual's dignity. Nevertheless, Rosen saw Bentham as defending privacy because, although extensive, such intervention would be neither arbitrary nor tyrannical. Rosen concluded that a well-ordered Benthamite state based on rational principles of security need not be a totalitarian one. I don't think Rosen's conclusion is fully justified, because obviously while arbitrary rule was indeed oppressive, that did not mean that non-arbitrary rule was not authoritarian. After all, one could strictly enforce a law requiring everyone to attend all government rallies and wave supportive banners while singing patriotic songs. The rule would be both non-arbitrary and authoritarian. There are more convincing reasons for seeing Bentham as respectful of personal dignity. In 1966, Negley praised Bentham for what he called, to quote, distinguishing carefully and distinctly the area of private individual action and responsibility from that of public and legal liability. Yet, end quote, yet Bentham was concerned primarily to stave off oppression of ordinary citizens by public officials, that is, the causing of wrong, quote, to a non-functionary by a functionary of any grade by means of the power belonging to him as such. And that's a quote from Bentham's code. The sole remedy, as he put it, for oppression was publicity. Even though, as noted above, publicity was effective primarily through the vigilance of the Public Opinion Tribunal, Bentham identified a number of other salient mechanisms. For example, he required that an official incidental complaint book be kept to record all official complaints lodged by citizens against public functionaries. Ministers were required to inspect their departments annually and to pursue any complaints of misconduct that citizens had lodged against their functionaries. Furthermore, restrictions should be placed on the information that the government was allowed to seek. Hence, citizens should be required to disclose a particular piece of information only if the cost of securing its disclosure was more than offset by the benefit that the community could reasonably be expected to derive from its disclosure. Such costs were partially financial, the expense of employing the public functionaries, the cost to the citizens of recording the information, and so on, and partly non-financial, for example, the vexation caused to citizens. Moreover, Bentham argued strongly for certain constitutional requirements in relation to the collection of information from its citizens. For example, the latter were to be notified clearly and in advance of what type of information they might be required to provide, and this notification must be recorded in the relevant nation's constitutional code. So these things have to all be set up impersonally in advance in the constitutional document. Bentham recognised that these protections alone were inadequate. The public disclosure of some types of information would almost always cause pain and vexation without generating a compensating benefit for the community. Hence he argued that, quote, the demand which the case presents is a demand for prudential care of the individual himself or those under whose guardianship his condition in life has placed him, but not for any interference on the part of the legislator. This passage could have been taken directly from Mill's On Liberty. The only significant difference between Mill and Bentham was that Bentham did not reserve this right solely to civilised societies in the way that Mill reserved the right. Which types of sensitive information or beliefs fall within this realm of privacy? Bentham was willing to endorse practices that most people would still regard as unthinkable. Indeed, he wrote but did not publish several works on these topics. For example, he advocated the legalisation of infanticide, concluding that in circumstances such as illegitimacy and poverty, quote, a more normal practice can scarce be found. Many of his views have gained far wider acceptance than this. Hence, in Code, he argued that public functionaries should not be allowed to inquire into citizens' religious beliefs, as this would be to act as, quote, as if the profession of such an opinion is regarded and treated as a crime, end quote. Yet the sensitive topic to which he returned more frequently than any other over the course of several decades was the legalisation of prohibited sexual practices between consenting adults, not least male homosexual relationships. Bentham's position changed very little over time. No sexual practice was, quote, unnatural or, quote, impure. What was repugnant to one person, to another, is most delightful, end quote. He argued that the very many people who condemned homosexuality invoked, quote, a false and spurious morality, end quote, which was surrounded by a cloud of prejudices. His view had definite utilitarian implications. He writes, applied to the field of morality and to the field of religion, then it is that nonsense becomes the most productive source of cruelty and misery. Countering such prejudices would tend to increase the mass of pleasure very significantly. Hence, Bentham argued that punishment for sexual deviance between consenting adults was, quote, pure evil. As such sexual deviance brought only pleasure and was, quote, pure good. The evil came from legal punishment. Homosexuality was punishable by hanging in Britain at this time. Infamy, fear of hell torment, the giving of false evidence against the innocent, self-banishment of homosexuals, fear of legal punishment and infamy, loss of enjoyment and pain from the sense of restraint and violence of restraint. These are all the negative things that came from the prejudices against homosexuality and other forms of sexual deviance. Obviously, the possibility of false accusation made a powerful instrument of exhaustion for something that, even when committed, was merely, quote, a matter of taste. Bentham considered and rejected all arguments that consensual sexual deviance was harmful. Its legalisation was an issue of, quote, truth, public utility and justice, in which Bentham advocated all comprehensive liberty. It was this type of clash between conventional morality and practices that should the law... this sentence is gone. It was this type of clash between conventional morality and practices that meant the law should not prohibit the practices on utilitarian grounds, that led Bentham to advocate significant safeguards for personal privacy. He did not discuss this matter directly in relation to the investigative powers of the non-judiciary state functionaries. It seems that in part he did not discuss it in that regard because he held that the state had a prima facie right to demand almost any piece of information which it deemed likely to be pertinent to the well-being of the community. Nevertheless, in his rationale of judicial evidence, he did consider cases in which that prima facie right should be curtailed due to significant utilitarian concerns for the well-being of the individual. His primary concern in this part of that book was to determine what evidence should be heard in open court and on the public record, and which should be heard only by the judge and, depending on the sensitivity of the matter, the other parties involved in the case and necessary court officials. Bentham rejected systems of secret courts, he said, there should not be anywhere a single one of these seats of despotism. Moreover, he rejected any system where judges only heard cases in secret, quote, the sense of responsibility, the habit of salutary self-restraint, formed under the discipline of the public school, that is, of open court hearings, will not suddenly be thrown away in the closet. In other words, judges build up habits in open court that they take even when they're considering things in camera. He highlighted 9 types of case in which publicity of evidence and court proceedings might be restricted. Where citizens might seek to disrupt court proceedings, where a witness seeks to make statements maliciously, where releasing certain information would expose the source of that information, thus rendering it liable to destruction, for example, where naming an informant endangers their life. Where publicity would harm someone's economic interests unjustifiably, where making specific information public would violate their legitimate privacy, where hearing certain facts would corrupt women and children, to preserve state secrets, where publishing evidence would be too expensive relative to the benefits generated, and where publishing the documents and transcripts would unduly increase the body of evidence. We are concerned primarily with the 5th item on the list. The 5th item on the list is where making specific information public would violate the party's legitimate privacy. Here Bentham considered cases where, quote, the peace and honour of families is concerned, by which he might well have meant cases involving adultery, sexual deviance and sexual assault, all of which he mentions in this chapter of the rationale of judicial evidence.
Sorry, would you mind repeating that 5th?
The 5th point is where making specific information public would violate the legitimate privacy of the parties involved. So he explicitly mentioned adultery, sexual deviance, and sexual assault as areas requiring sensitive handling of the evidence and not making it public as being a presumption. In those circumstances, quote, publicity can have no better effect than that of pouring poison into whatever wounds have already been sustained. End quote. Then the judge should do whatever he deemed necessary to maintain the privacy of the relevant party, with Bentham's preference being that the judge should hear sensitive evidence in a private room away from the other parties and the members of the court. More than this, the judge should punish people who disclose sensitive information with the purpose of harming the reputation of the other party. He writes, there seems no reason why malicious vexation in this shape should go unpunished, any more than in any other. Bentham's overriding goal was simply, quote, to preserve individuals from unnecessary vexation. Hence, the judge might, end quote, hence the judge might choose to impose a fine, for example, where the malicious party, quote, demands his pound of flesh, his right of tormenting his adversary, by dragging into the daylight all those shades in his character, which, for the tranquillity or reputation of one or both parties, their families and their connections, had better have remained in darkness. Despite his defence of privacy in these terms, Bentham still insisted that judicial proceedings be kept public except where not doing so was likely to serve the greatest happiness of the greatest number. Moreover, even where evidence is heard in private, records of the testimony must be kept. Such record keeping helped to ensure that the judge did not exercise, quote, a power completely arbitrary, and to ensure that miscarriages of justice could be identified and rectified, and conversely that the innocent should be vindicated by subsequent scrutiny of the evidence on the basis of which the original judgment had been made. Finally, he held that privacy would be justified in a relatively small number of cases only. This section has shown that Bentham held very liberal views regarding some of the most intimate aspects of an individual's life, and despite famous allegations to the contrary, he placed important restrictions on the handling of sensitive personal information. I'm going to skip ahead just to the final paragraph. Whether or not Bentham's belief in the power of reason seems too naive in an age of corporate control of governments and media, ultimately he's not open to Foucault's criticism. Bentham's writings on open government and publicity were profoundly significant in his own day, precisely as the most extreme proposals then current for the creation of an independent, critical and well-informed civil society to act as a powerful check on public functionaries and private institutions. Ultimately, Bentham's was an especially radical position in an age of profound deference in which the vast majority of the population accepted social hierarchy, exclusion and corruption as cornerstones of many nations, not least the United Kingdom. He held that only with complete freedom of press and discussion and association could the Public Opinion Tribunal shed the light of publicity into otherwise dark corners of the state and the sinister interests which dominate civil society, thereby violating the greatest happiness principle. For these reasons, it seems almost impossible to imagine anyone who would have welcomed WikiLeaks and Edward Snowden's revelations and the Panama Papers more fervently than the octogenarian Jeremy Bentham.
Many thanks indeed. That's fascinating.